A very happy new year to all the respected members of the bar.
With the consent from all the parties, we have to mention item number 2.
Yes. Yes.
This matter may be listed after 2 weeks.
You are the counsel for the
For the respondent.
for respondent number?
Only this.
Sole respondent.
sole
Sole. Okay. On the prayer of Mr. So-and-so, learned counsel for the sole respondent, listed after 2 weeks.
Much of it.
Your Lordship, I beg to mention item number 5 and 6.
5 and 6.
Yes.
Yes, ma'am. What is the prayer? You're the counsel for the?
I'm on the behalf of Sunil Mao.
The counsel for the
My lord,
Respondent.
I am for the appellant, my lord.
appellant.
Yes, my
So you're for the
Respondent, yes, Your Lordship.
You are mentioning on behalf of
S. Mao. Sunil Mao.
S. Mo.
Yes,
Okay.
Your Lordship.
Yes, what is your prayer?
Sorry, Your Lordship.
What is your prayer?
Maybe fixed on 13th of February.
MS so-and-so, learned counsel, makes a mention on behalf of Mr. Sunil Mao, the counsel for the respondent, and seeks adjournment of the case on
30th of February.
13/1.
Yes, 13th.
I'm sorry. 13/2/2024. Prayer is allowed, listed accordingly. Okay. Okay.
My lord, there is a interim order, madam.
Okay.
That may be continued.
The interim order passed earlier shall continue till the next returnable date.
My lord, diplomat.
Much of it.
May I, my lord? My lord, this item may be list on 7, my lord.
On 7th.
On 7, my lord.
Why? Why? 7 is an auspicious date.
No, my lord. My senior, Mr. T. Tara, my lord, he has some personal difficulties, my lord, today, my lord.
Mr. So-and-so, learned counsel for the
Petitioner.
petitioner. Submits that the matter may be listed on 7/2/2024
Yes, ma'am.
as Mr. T. Dara, the learned counsel leading the case, has some personal difficulties today. Prayer is allowed, listed accordingly.
Much of it.
May I please, my lord?
Yeah.
My lord, this is an IA application for condonation of delay, my lord, and the respondent has filed objection, my lord. My lord, I had some default on the part of our counsels, my lord. So I may be allowed to file an additional affidavit, my lord, explaining the reasons of delay, my lord. Only 2 weeks time, my lord, further may be granted, my lord, as a last chance, my lord.
Mr. So-and-so, learned counsel for the applicant, submits that he may be allowed to file. He may be granted 2 weeks' time to file additional affidavit explaining the delay. Prayer is allowed, listed after 2 weeks.
Highly appreciate, my lord.
Your Lordship,
Yes, ma'am.
this IA is for condonation of delay of 67 days, Your Lordship.
Lordship.
Lordship, for
For
the,
the opposite party?
yes, your Lordship,
Oh.
I have no objection, your Lordship.
Opposite parties, all the opposite parties?
All the opposite parties, 1 to 7.
Okay. What about 8?
Lordship, the opposite parties is from respondent number 1 to 7, your
Seven.
Lordship.
Response.
Page number 8,
One,
7 and 8.
okay, okay.
Got
Written petition. Where have you explained the delay, ma'am?
Lordship, I have stated my grounds in paragraph 2 and 3, Your Lordship, of my
Paragraph?
2 and 3, Your Lordship.
Her MS. So and so. The learned counsel for the applicant. This application has been filed under section 5 of the Indian Limitation Act 1963 for condoning the delay of 67 days in filing the connected appeal. The grounds explaining the delay is set out in paragraph 2 and 3 of the application. So we have perused paragraph 2 and 3 of the application, and we are satisfied that the applicant has been able to satisfactorily explain the delay. The delay of 67 days is accordingly condoned. MS so-and-so. Learned counsel appears for all the respondents. Stop. The application accordingly stands disposed.
Lordship.
The
Lordship,
main appeal
in
may
the
be
main case, writ appeal, this matter may be listed for hearing, your Lordship, after 2 weeks.
after 2 weeks.
What is writ appeal?
Writ appeal
36,
36.
writ appeal 36.
Writ appeal 36, okay? In view of the order passed in IA 193 within bracket AP of 2023, the appeal is admitted for hearing in the usual course.
Obliged.
Yes,
Please, my lord. My lord, I beg to mention item number 28, ma'am.
20.
8 to
28.
8.
Yeah.
May I humbly pray, my lord, the matter may be released after 2 weeks, my lord. I have informed
You are the
the,
counsel for the,
yes, sir, the government's counsel.
you are the counsel for the,
I am counsel for the petitioner, my lord.
your good name?
O Pada, my lord.
O.
Pada.
O Pada.
Yeah, my lord.
On the prayer of Mr. O Pada, learned counsel for the petitioner, the matter stands adjourned after 2 weeks.
Obliged, ma'am.
None appears for the petitioner on call. Listed after a week. Replayable.
May it please your lordship.
Yes.
My lord, item number 2, item number 4. 2, 3, 4 and 6. 2, 3, 4 and 6 may kindly be taken up together, my lord. 2, 3, 4 and 6.
Yes.
Now, my lord,
Let us.
we'll start with 2, my lord. My lord, the brief fact of the case is this, my lord. A notice inviting tender was floated under the MREGA, my lord, Mahatma Gandhi National Rural Employment Guarantee Act. An NIT was floated for different packages for different areas, my lord. Now, my lord, I take your lordship to the NIT at page number 17, 17. My lord is there?
17.
17. My lord, put it on 11th of August 2023. Now, this is for supply procurement materials under MRE 2023-2020 in respect of CD block, Parsi, Parlo, Urumkume district, Arunachal Pradesh, my lord. Now, my lord will kindly come to clause number 5. Tender paper shall be received by the office of the project director DRDA such and such place up to 12 AM on 5/9/2023 and shall be opened at 1 PM on the same date. That is, the tender was supposed to be, the tender dropping date is 5/9/2023 and the tender opening date is also 5/9/2023, my lord. Now, my lord, in response to this tender, my lord, the petitioner before your lordship has submitted his tender, my lord. Now, my lord, the tender was supposed to be opened on 5/9/2023. Now, there was a considerable delay in opening the tender. Having seen the delay, my lord, the petitioner sensed some foul play. Accordingly, my lord, the petitioner filed an RTA application regarding the minutes of the tender and the other detail of the tender in question. My lord will kindly see page number 36 is the reply which was furnished on 25/1/2024. My lord has seen, my lord. Now, along with this reply, the board proceeding of the tender revision committee was furnished to us, which is at page number 37. Now, Lord, here it says, in pursuance of NIT, it has to be floated. It is written here floated. Wide order number such and such, there is the same order number which is reflected in the NIT, dated 5th October 2023 and 30/10/2023. The board member assembled in the conference hall of the DC of Deputy Governor so-and-so on 5th of October 2023 at 11 AM in the presence of all the bidders. All tender papers were found in sealed cover. But, my lord will kindly take note of this. But, Sia Enterprise, Messrs. O2 APA developers was rejected by the members due to an unsigned Enterprise is the private respondent here. His tender, according to the tender evaluation committee, was unsealed. Therefore, it was rejected. The both firms was reopened on 30 as honorable court direction. Wide order numbers were opened for scrutiny in front of all the board members, the bidders. Now, my lord, this is the remarks against each of the bidders. Now, the petitioner before lordship is the name of the petitioner's firm appears, that is Messrs. LT Enterprise. The rate code Thereafter, it was found that one of the mandatory requirement, that is Form 6, that is at page 34, he has not submitted that. Page 34, my lord will see. This is one of the mandatory requirement. That is, this is declaration. This is a declaration to the, such as this is a pro forma, my lord. That is what they will have to fill and submit, my lord, with the sign and signature. Having visited the site and examined the bid document, including invitation for bid, instructions to bidder, general specific, additional condition of contract, appendix to bid, specification, bill of quantities, drawings, and all these things, that they give a declaration that they have done, or they visit the site, they will complete the work, and all these are mandatory declaration that has to be filed.
Who is for the government? Yes. Issue notice? Yeah. Yes, please.
Your lordship may please come to 29. This is the terms and conditions of the NIT, my lord. Page 9, my lord.
29.
Yes, my lord. 15, my lord. Award of supply work order. May I read, my lord? The tender shall be evaluated by the board constituted by PD cum ADC at district level and recommended at least 3 firms to competent authority for along with all relevant documents. Now, clause 2, my lord. The Director RD Engineering Wing shall further scrutiny the tender documents recommended by the PD cum ADPC. The LOI will be issued the L1 form duly recommended by the ADPC, my lord. By instruction, my lord. It is, they don't have any authority. The district administration does not have any authority to reject any tender documents, my lord. They have to only recommend it to the director. Now, directorate will again need the documents, my lord. All the scrutiny of the document, it was found that the technical bit of petitioner found non-responsible. There were some lapses, my lord, due to which his technical bit has been rejected, my lord. Basing on this section, clause 15, subclause 2.
Okay, you get necessary instructions.
My lord, may I?
My lord, my only prayer at this stage that the tender process may not be finalized, my lord. Because, my lord, this is ex facie, my lord, they are indulging in arbitrary act, my lord. Ex facie. The recommendation of tender board, the findings of the tender board with a one stroke order, the director issues this to a person with all these anomalies and defects, my lord. Ex facie illegal. That's what, my lord, my humble submission.
Secondly, my
There
lord,
is an
my submission, my lord. Secondly, my lord. Second is that our secretary has not been made as a party. There is a technical defect in the writ petition itself. Secretary is not a party here. Who should be represented? Section 80 of CPC, my secretary has to be made as a party.
which secretary?
The secretary RD has to be made as a party. Chief secretary is not a necessary party.
My lord, in a read proceeding, my lord, if you go by the strict rule of CPC, my lord,
And my lord.
but the all the tender,
Sanso, your good name, please.
Manojit Biswas, and
Sanso,
May, my lord.
learned counsel for the petitioner. The notice inviting tender for
My lord, may I, my lord? I may be allowed to bring the records. My lord, it may be taken up tomorrow, my lord. I will bring the original records, my lord.
tomorrow,
Tomorrow, my lord.
otherwise not possible. My court holiday is there also. tomorrow.
Day after tomorrow, my lord. No. Because stay would be, my lord, impact the villagers also. Because this MG Narega scheme, my lord, is a wage and non-wage item. In wage item, my lord, villagers get some, my lord, incentives, my lord,
My
in
lord,
terms of money, my lord.
that is precisely why, my lord, they need to be more fair in their dealing, my lord. The state cannot act.
If there would be
arbitrarily.
any stay, my lord, the sufferer would be the villagers. The scheme will.
Villagers will further suffer if a tender is given to a person who is otherwise not qualified to execute the work.
Anyhow, villagers will get benefit.
They will suffer
Yes, ma'am.
further.
Notice inviting tender for supply and procurement of materials pertaining to Narega. How do you pronounce this?
MG Narega.
MREGA, Mahatma Gandhi
Ah.
Rural
How-
Employment.
How, in short, how do you pronounce it?
MREGA,
MNREGA.
MG and Rega, MG and Rega, MG and Rega, yes.
Pertaining to so and so 2023-24 for CD block Parsi Parlo under Kurung Kume district. Being package number 2 was invited by NIT dated 11/8/2023. It is the case of the petition stuff. It is the case of the petitioner that the bid submitted by the petitioner was found to be L1. And the technical bid submitted by the private respondent number 8 was found to be defective. Stop. The tender evaluation board has accordingly recommended the name of the petitioner for approval. But stop, but the respondent number 2 has issued the impugned letter of intent within Brigade LOI. To the private respondent number 8. Without following the recommendation made by the tender evaluation board. And in violation of the various terms and conditions of NIT. Issue notice to the respondents. You have all the respondents?
I'm for respondent number 2, my lord. 2 to 7.
Issue notice to all the respondents. Returnable in 3 weeks' time. Since, Mr. Your good name,
VP Chawla.
so and so, appears for the respondent number 2 to
7.
2 to 7.
Yes.
And
6 for 1.
And MS so and so, learned counsel appears for the respondent number 1. No formal notice need be issued to the said respondents. The learned counsel for the petitioner shall, however, serve the requisite copies of the writ petition to the learned counsel for the respondents. When?
During the course of the day or by within 2 days?
In the course of the day.
In the course of the
Stop. Insofar as the respondent number 8 is concerned, the learned counsel for the petitioner shall take steps for service of notice upon the said respondent by registered post with AD within a period of
2 days.
within a period of 2 days from today. Who has issued this notice?
Director, that respondent number 2.
So considering the submissions made by the learned counsel for the petitioner. And also considering the facts and circumstances of the case. This court. In the interim. States. The letter of intent dated. 9/1/2024.
My lord, it is 8. Page number 40.
8/1/2024. Issued by the respondent number 2. Stop. By respondent number 2 till the next returnable date. It is also further directed that the respondent authority shall not finalize the tender till the next returnable date.
I'm so deeply obliged, my lord.
If finalized,
My lord. Already, an item number 3, item number 3 is same, my lord, exactly same ground, same, my lord.
What is the difference?
Only difference is the package number and the place. It is pertaining, it is package number 4 and the place where the work is Colorian CD block.
Okay, ma'am. You got it? Okay.
Colorian CD block, please. And impugned orders are everything.
What about respondent?
Private respondent 8.
8.
8.
Okay. So take note of that, ma'am. Okay. Okay.
my lord, returnable
Now-
8, my lord,
After 3 weeks.
3 weeks. After 2 weeks, my lord.
3 weeks.
Now, item number 4, my lord. This is also with regard to the same MG and Rega, my lord, with regard to a different place. And my lord, here package number is 4 and the CD block is Polosang, POLOSANG. CD block package.
Ma'am, you just see the NIT. NIT, you'll get the.
Yes, my lord.
What about the other?
6 also same because these are different.
6 also same.
6 also
You
same.
just check up with the NIT. Okay.
Only the block name and the pack. It is there in the NIT. 6 is package number 8 and the block name is different. Sorry. I'm deeply
Same
obliged.
order? Same order?
Say, same order, same date. Even the interim date is also same, my lord, 8/1/2024. Clarification is also sought.
Okay.
Same, my notes.
Okay.
Give you-
Obliged, my lord.
The petitioners are different in English.
My lord, I'm extremely sorry, my lord. I was for item number 1, my lord, which has been posted for after 1 week, my lord. So instead of 1 week, my lord, this may be taken up on 7th, my lord. I have taken concern from the other side
Okay,
also.
ma'am. Item 1.
Yes.
Item 1. That was listed on 7th.
So, most of my.
7/2/2024. Okay. Item number 5. Yes.
May I please, your lordship? Lordship, this is non-payment of the pending bill, my lord. And my lord, the one person has already been paid, my lord, which has been received by the petitioner for execution of certain works, my lord. The NIT is at Annexure 1, page number 16, my lord. This is for, my lord, installation, supply and installation of
Page.
page number 16, my lord. Annexure 1, page number 16. My lord, this is the NIT issued by the respondent department, my lord, supply and installation of
This
the
is for supply and installation
my lord,
of computer and accessories
correct, my lord.
that work.
This is the work, my lord. And the estimated cost of the tender is 8 crore 38 lakhs, my lord.
Estimated cost.
Yes, my lord. And accordingly, my lord, this work was awarded to me, my lord, the petitioner, Annexure 2, my lord. Page 17. Letter of award for the work, supply and installation of my lord, same works. And formal agreement was entered into between the pilot, the respondent authorities and the petitioner, my lord, Annexure 3, my lord. And accordingly, my lord, after the award of the work, my lord, the petitioner executed the work and completed the work. The completion certificate is at my lord, Annexure 4, page number 24, my lord. Work completion certificate, my lord. This is to certify that I mean, so and so, my lord, petitioner, so and so has successfully and satisfactorily completed the whole work. The details of the work executed are as follows, my lord. These are the work, my lord, the date of completion, my lord, serial number 8, my lord. Date of start of the work, serial number 7, serial number 8, my lord. Completion of work, 18 December 2021, my lord. Thereafter, my lord, everything was, my lord, the completed as per the, my lord, the permit as per the requirement, my lord. Now, my lord, only, my lord, I have been paid to the tune of, my lord, 1 crore. My lord, I have categorically stated at in my petition, my lord, page number 8, paragraph 8, my lord. The out of the 100% of the total project cost, only 20% of the payment has been made to the petitioner till date. That is, Rs 1 crore 96 lakhs, my lord, which is, my lord, stated to be a state share, my lord. Admittedly, my lord, the state share or, my lord, the central share, my lord, it is not the none of the
What is this PMA charges?
PMA charges, my lord, PMA. My lord, I haven't any idea. Maybe, my lord, this is project management, my lord, or other auxiliary charges, my lord.
So you
This
have been
includes,
paid-
my lord,
You have been paid 196.
196 crore, my lord. And, my lord, as per the, my lord, the total work, my lord, I am entitled, after deduction of this work, my lord, it comes to, my lord, 6 crore 42 lakhs, my lord. This is the, my lord, defending liabilities, my lord. In fact, they are also not disputing, my lord. The respondent authorities, my lord, they are only contending that, my lord, this is the central share which has to be released by this, my lord, the central government department, my lord. But my lord, deliberately, my lord, we have not, my lord, made the central government as one of the necessary parties because, my lord, the tender, everything was entered into between, my lord, the petitioner and the state government, my lord, tendering authority, my lord. And nowhere, my lord, it has been directly connections with the, my lord, the sponsoring authority, my lord, that is the central government. So therefore, my lord, at this stage, may I pray that, my lord, notice may be issued to the respondent authorities. And, my lord, the time and again, we are, my lord, making representations to the government, my lord, the respondent department, and even legal notice was also issued. But there is no any response from the, my lord, the authorities till date, my lord. In fact, we have submitted the representation, my lord, the last representation is at Annexure 7, page number 38, my lord. 38 May to page number 38, my lord, Annexure 7. This is the representation dated, my lord, 30th May 2023. Written to the, my lord, the nodal officer and, my lord, the tendering authorities, my lord. Chief Engineer, Power, my lord. Request for my lord, the immediate release of the long pendings of the IPDS, the bills for the works, supply and so, same work, my lord. Till date, my lord, there is no any my lord, response. My lord.
Lord,
This-
Mr. So-and-so, your good name, please.
M. Katam.
So-and-so, the learned counsel for the petition. And notice inviting tender dated 2/1/2020 for supply and installation of computer and accessories, comma, networking equipment, comma, meters and GPS based survey under IPDS phase IPDS, oh, IPDS PH2. For enablement of all 16 towns within bracket urban of IDPS, urban close bracket of IDPS, was issued by the superintendent engineer within bracket E, APEC -1, Nahalagan, Department of Power. So the petitioner being one of the tenderer was awarded the LOA, letter of award dated 2/3/2020 for the said work. Stop. It is submitted that in terms of the letter of award, the petitioner has completed the work and the work completion certificate dated 7/3/2022 was issued by the superintendent engineer within bracket E, Arunachal Pradesh Electrical Circle -1, Department of Power, Naharlagan, within bracket AP. It is the case of the petitioner that despite the completion of the work, only 20% of the total project cost, amounting to rupees 1.96 crore, has been released to the petitioner. But the remaining amount of rupees 6.42 crores is yet to be released. Stop. The petitioner has submitted the representation dated 35/2023, requesting for release of the outstanding bill. However, the same has not evoked any response. Stop. Being agreed, the petitioner is before the school. Issue notice to the respondents, returnable within 4 weeks. Mr. Your good name?
L per me, my lord.
So and so, you are for
1, 3 and 4, my lord.
1,
3 and 4.
1, 3, and 4. Mr. So-and-so? You're,
per minute.
Government advocate,
Yes, Standing Council Power Department.
Mr. So-and-so, Learned Standing Council. Appears for the respondent number 1, 3, and 4. Therefore, no formal notice need be issued. The learned counsel for the petitioner shall, however, serve the requisite copies of the writ petition to the learned standing council within
2 days, madam.
within a period of 2 days from today. Insofar as the respondent number 2 is concerned, the learned counsel for the petitioner shall take steps for service of notice upon the said respondent by registered postpaid AD within a period of
Madam.
2 days
2 days.
from 2 days. Okay.
Malad, just a small observation, Malad. However, Malad, there may be chances of the Malad, the mitigating step, Malad, the parties. So, Malad, the pendency of this may not be a bar for the.
Pendency of the writ petition shall not be about to the respondents to release the outstanding liability
Madam.
to the petitioner.
Develop-
May I please, your lordship?
Yes.
Lordship may kindly peruse previous order, lordship, whereby this honorable court has directed the state authority to examine whether this matter in hand is covered by
Which order?
lordship. I have the order with me, lordship.
Which is
Previous
the
order, lordship.
Today's order?
No, previous
Previous order,
order dated 31/1/2024, lordship.
yes, government.
Malad, here I am appearing on behalf of respondent number 5, Malad. Malad, so far I haven't received any instructions from the Malad, the concerned department, Malad. After all, Malad, this is the this department is the Malad,
What is the matter about?
Lordship, the matter is in regards to land compensation, lordship.
Land compensation.
Land compensation.
May I friendly Malad, some more time may be granted. So that,
Lordship,
take
clear-cut
instruction.
observation is there, lordship. Lordship may kindly peruse, lordship. In the previous
Your for-
proceedings, lordship.
Respondent number 5, Malad, commanding officer 11 RCC, Malad. Malad, my name is not shown in the Malad, the cause list also, Malad. That is the one difficulty, Malad, where I have observed, Malad. This case seems to be filed in the year 2022. Malad, no copy, Malad, correspondence has been made.
What about government?
And it is also not known, Malad, whether copy has been served according to me or not, Malad. Or to the respondent number 5, Malad, personally.
Mr. S. Tapin. You're for respondent? 1, 3, and 4. 1, 3, and 4.
No, I am for two only, lordship.
You're
I
for
am
two.
Student Council Land Management Department. In fact, lordship, the judgment of order supplied by the council for the petitioner, lordship. We have in fact conducted that writ petition and even state file writ appeal also. It was me who was conducting the writ appeal. And that is the judgment which has been placed before your lordship.
So there is a covered case, what you mean?
Yes, I fairly have to submit, but only the issue is that the union government has not been supplied with the copy of the writ petition.
Lordship, I have
Otherwise-
supplied, Lordship. I have the
otherwise-
receipt with me, Lordship. He cannot contend
In
it.
that case,
Well, the difficulty is, as per the
Yes,
record,
Mr. Stoppin. You don't have much to say.
Because money has to come from Lordship, one train only, Lordship.
The most important person is yet to.
Lordship may kindly peruse the.
Yes, I have
please.
perused. But let us give some time to
My
the
since I am
government. Because actually the money has to come from them. So at least let us be fair. Let us give them some chance.
Lordship, since he is contending that he has not received the copy, Lordship, I have the
Maybe
record with
My
me,
difficulty
whereby he has
is one
received
of my
his copy or.
brother has received, my lord, and that has not been my lord placed to me, my lord.
So it will not be necessary for the state to file any affidavit also.
Because in the meantime, if Lordship, because I am yet to receive the.
Because office note shows that the counter affidavit is yet to be filed. by the receipt.
I have not yet received the instruction. But when I see the judgment passed by this group, the earlier, issue is almost,
More or less same.
because it's over the same stage. From 0 to 6. And 6 to 16 only was what I. Anyway,
So I think you have nothing much to do except expedite releasing the money as an early deed.
My lord, even we don't
It
know
is
how
a
much
covered
the money
case.
has to be released.
For that we are giving you a chance.
My lord, some more time may be granted, my lord. In the meantime, I'll take instruction from the department.
You are for respondent number 2.
yes, sir.
What about one?
One.
Yes.
Yeah, do the claim on this.
Your good name, please.
M. Carter.
I'm the Kamdul. The Kamdul.
Mr. Stapin, you are a senior government advocate or additional AG?
Senior government.
Mr. S. Stapin, learned senior government advocate, appears for respondent number 1, 3, and 4. Mr. Your good name? Yes.
I'm the Kamdul.
So and so. Appears for the respondent number 2.
Yes.
The so and so, then standing counsel appears for the respondent number 2. And Mr. Your good name?
M. Kato for respondent number 5, my lord.
Learned counsel appears for the respondent number 5. Hold the learned counsel for the respondent. 6 for some time to file their respective affidavit in opposition. Where is allowed? Listed after 3 weeks.
Lordship, since there is observation from previous court's order, Lordship, if courts finds that if it is a covered case, affidavit of
Okay,
opposition
we
is
give them
also-
some time, listed after 3 weeks. The name of Mr.
M. Kato, my lord.
So and so, learned,
DSJ,
CG, DS,
GI, my lord.
DS, Deputy
Deputy Solicitor General.
DSGI. Shall be reflected in the daily cost list. Stop registry to take steps accordingly. Listed after 3. Okay.
Development.
My lord, I have not received instruction. I may be given last opportunity to file affidavit in opposition.
You're for the
I'm for the
State.
state respondent.
state,
Yes,
state.
RWD.
One, two, three, four.
Yes.
All.
I am for the petitioner, so my lord, this observation may be made my lord, last opportunity.
Last,
And,
that last is very important for you.
Standing council RWD.
You are the standing council
Yes,
of which department?
RWD, rural work,
Standing council
RWD.
of RWD.
Yes,
What is RWD?
rural work department.
Rural Working Department. Mr. Swenson. Leonard Council for RWD submits that he is yet to read, he is yet to receive the instructions. And therefore 6 for 3 weeks time. Prayer is allowed. Stop, okay? Prayer is allowed. Listed after 3 weeks. It is, stop. It is made clear that no further adjournment shall be granted to the respondents.
No place.
My lord, this item number 9 and 10 are similar,
9 and 10.
9, 10 are similar matter, although the petitioner are different. My lord, this is a small, this is a bill pending matter of this a small amount which is pending since last 2022. And accordingly, we have filed for the releasing of the bill amount in the 2023. And as the bill amount has been verified and all the assessment measurement has already been done, and even the department themselves has sought for the payment to the chief engineer, which is on the record, Annexure A. So till that they have not released the bill amount. And in this case, as per the record, even the affidavit.
We have received the instructions, my lordship.
You
We
have
decided-
not released the bill, you have not filed counter affidavit.
We have received the
And it's
instructions, my lordship.
pending
We'll
for
be
last.
filing.
So since
Let
1 year,
them-
they are just seeking. And,
Let them file. Let them
My
file.
lord,
their-
my lord, if we see from the record, even if affidavit is not required, all the
No,
done
no.
has been admittedly they have
At least we give chance to the state to file affidavit. Let us see. their
they
time.
have the certificate that the following project amounts source of planning year, geotagging, all this has been already done, and there's been submitted
See,
before the.
Leonard Council, that is your case. The state may have some other issues.
Mm.
Let them file their affidavit. Let them file their affidavit.
My lord, so that maybe since the status is the report has been already
weeks,
sorted
my
out.
Ma'am, you are the government advocate or
Yes.
standing council?
Government advocacy.
Government.
So then, my lord, as a without fail must be recorded because since for 1 year it has been pending.
So you're for all the respondents?
Yes, my lordship.
MS Swenson, the Leonard government advocate. For all the respondents. 6 for 3 weeks time
2 weeks, my lord.
to file affidavit in opposition. Prayer is allowed. Listed accordingly.
Oblige, most oblige.
My lords, I am appearing on behalf of petitioner in item 11.
My lord, I am appearing on behalf of all respondents, my lord, GST, my lord. Department of Revenue, my lord. May I pray that, my lord, some more time may be granted so that we can file, my lord, appropriate affidavit, my lord.
You have still not filed your affidavit?
Yes, my lord. In fact, we have already communicated to the, my lord, the department,
For all the
all the
respondents?
respondents, my lord. Matter pertaining to, my lord, the GST, my lord.
Yes, the learned DSGI requires some time to get instructions.
All right, sir. All right, madam.
Mr. Your good name?
M. Kato, my lord.
M. Tato.
Kato, KATO, my lord.
M. Kato.
Yes, my lord.
KATO.
My lord.
Mr. M. Kato. The learned DSGI submits that he is yet to receive instructions and therefore seeks for 3 weeks' time. Prayer is allowed. Listed after 3 weeks.
Developers.
My lords, may I also mention a similar matter, item number listed at item 24, my lords, in the name of ITI Limited. My lord,
Mr.
this is
Keith,
also a similar matter.
My lord.
You are also for.
Yes, ma'am.
24? Same order?
In this matter, yes, madam. In this
Same
matter,
order.
my lord,
Same
we have
order?
already communicated, madam.
Same order?
Same order, madam.
My lord, same order, it has to, just interim relief need to be extended, in this matter, my lords.
Pardon?
The interim relief was granted, in the order, and, the interim relief, shall be extended, my lords.
Interim in your favor? In your favor?
Yes, my lords, interim relief, my lords.
You are actually making a submission for extension of the interim prayer.
Yes, my lords, in the last order, it was mentioned, my lord, the interim order passed earlier.
Is there an interim order?
My lord, on the first occasion when matter was listed, I was not there, my lord. Therefore, my lord, considering the, my lord, matter, my lord, interim protection has been given to the petitioner, my lord. First order, my lord.
The interim order passed earlier shall continue till the next returnable date.
Obliged, my
Develop.
lord.
My lord, this, the board of matter may be listed together, my lord. Since
This
matter
is
is connected matter, my lord.
this
Item number 24 and 11, my lord.
11, huh? In WPC 11, okay? Item 11.
Yes, my lord.
The present writ petition shall be tagged with WPC 552/2022 and listed together.
Yes. Develop.
Deeply obliged, my lord.
Okay.
My lord, matter has become infructuous, so I may be allowed to withdraw the matter.
You're the counsel for the petitioner,
Yes,
Mr. So-and-so, the learned counsel for the petitioner submits that the matter has become infructuous and therefore he may be allowed to withdraw the petitions. Writ petition is closed as withdrawn.
obliged.
Here, Your Lordship, we have to file for respondent number one also, Your Lordship, our affidavit, Your Lordship. I may
Affidavit
be
in
given some
opposition.
time, Your Lordship.
Respondent number
One,
one.
2 and 3, we have already filed, Your Lordship. But in respect of respondent one, we have to file.
None for the petitioner. None appears for the petitioner. Stop. Mr. So-and-so. The learned
Government advocate, Your Lordship.
government advocate. He is allowed 3 weeks time to file affidavit in opposition on behalf of the respondent number one.
Oblige, Your Lordship.
Yes.
My lord, I am appearing on behalf of all the private respondents, my lord. Respondent number 5227, my lord.
Phone number 4.
And my lord will file affidavit, my lord. 3 weeks that may be granted, my lord, in the meantime. my lord. File complete.
Only respondent number 4 is filed.
We have filed.
Yeah, 4. For respondent number 4, that is deputy
Yes.
commissioner. You are for?
My lord, I am for respondent number 5227, my lord. All private respondents. my lord.
And yes, you are for?
Let's try for respondent number 2 and 3.
2 and 3.
Yes, sir.
Have you filed your affidavit?
No, sir, no.
No, not necessary.
We'll file those.
You are the standing counsel,
Yes, yes.
Mr. So-and-so. The learned standing counsel for the respondent number 2 and 3. And Mr. So-and-so,
For respondent number
the learned
5227.
counsel for the respondent number 5 to
27, my lord.
5 to 27. What about 28, 29, 30?
My lord, in my petition only up to 27 is
Yes, ma'am. 28, 29, 30.
That I am not aware of that.
You are representing
I'm petitioners.
petitioner.
Yes.
This is your petition.
Yes, Your Lordship, but I was not appearing. It's first time I'm appearing. Yeah.
Lordship, it seems that this earlier petition was amended.
Yes.
And
it's-
subsequently these respondents were incorporated.
28, 29.
Yes, now petition Lordship is only up to 27. Where not supplied with the amended petition is which was amended.
Amended, yes. This is amended. Have you taken steps 28, 29, 30?
We should have taken.
And it seems that it is the Union of India, my lord. I ought to have represented these newly implemented respondents, my lord. My lord, before that, I entered appearance on behalf of respondent, private respondents.
You either have to choose one of.
My lord, in that case, my lord, I'll refer to the department for appointing of the other CGC, my lord. Since I am already appearing in the matter, my lord. When the my lord notice was issued, and when I accepted, only the up to respondent number 27 was made, my lord. But my lord, subsequent development, my lord, it is not.
I believe you have to withdraw yourself wholly. Because when you are
My lord, otherwise also, we are in the same, my lord, respondents. my lord.
whether there is any clash of interest.
To my understanding, my lord,
Huh.
there is no, my lord. No, my lord, the conflict of interest is because we are in the same puttings, my lord, the same respondents, my lord. In fact, it is already decided case, my lord. On the several proceedings
Because
was held
when you are continuing as the DSGI,
my lord.
in the same case, you cannot appear for the private respondents when the Union of India is a party.
My lord, since Union of India is also in the my lord, the same respondents, my lord. In that case, my lord, I can, my lord,
Ma'am, you take steps. Okay,
Yes, Your Lordship.
for service of notice.
Yes.
What was the last? Pardon? Six, 4. 3 weeks time to file their respective affidavit. Prayer is allowed. Listed accordingly. Stop. The learned counsel for the petitioner shall take steps for service of notice upon the respondent number 28, 29, and 30 by registered post with AD within a period of, ma'am, within a period of,
2 days.
within a period of 2 days from today. Okay.
And the petitioner may be directed to supply the amended copy of the petition.
To all,
My lord.
Yes.
I have
The-
received knowledge.
you have received. The learned counsel for the petitioner shall serve the copies of the amended writ petition to the learned counsel for the respondents within
I will do it tomorrow.
within
2 days.
within a period of 10 days from today.
My lord, deeply appreciated.
You.
Item number 16, I am appearing for the contemner. But today, 16. Today I am filing the affidavit of opposition, wherein my lord, the contemner tender unconditional apology.
Have you complied?
Yes.
Unconditional apology is one
Yes,
thing.
yes, my already complied.
But my instruction till a day before yesterday was that although I have been allowed to join, but the person whom I had to rely, he is yet to be released from the post. So virtually there is 2 DDCs in the same district.
What
So-
is item, this is your for item 16.
Yes, I am.
What about item 17, 18, same? What
Yes,
is the matter about?
this is a writ petition, Lordship. I have challenged the modification order. In fact, in the earlier order, I was transferred from GECO, where I was serving as principal, as DDSC East Siang District Pasigar. After the issuance of that order, transfer order, authorities has modified the order, retaining me there in the same school as a principal, and the present incumbent who is holding the DDSC post at East Siang District, he has been retained. Otherwise, the earlier transfer was vice versa. He had to go to GECO as a principal, and I was supposed to be the DDSC of the East Siang District. I had challenged that modification order. And that was stayed till the disposal of this writ petition. Now, after that order was passed, interim order was passed, I tried to join during Pasiat as DDSC. But my joining was not accepted by the Deputy Commissioner. So I had to move this Honorable Court by filing press writ petition. In this press writ petition, contempt has been drawn against the Deputy Commissioner.
You have filed a WPC 452.
For both the writ petition laws.
Both the writ petitions are still not disposed.
No, it is not disposed. Both are pending lawsuit.
Yes. You said you have complied, but the person is not allowed to join.
My lord, already they joined on 20 November 2023.
Have you got the joining report?
Yes.
No, sir, that is not disputed. I have been allowed to join, but I am not allowed to discharge as a DDC now because of the reason that the present incumbent, who has been transferred to GECO as principal, he has not been released from the.
No, but that is for the department to take a departmental action. So far as contempt is concerned, they have complied. So we cannot go.
The department law, sir, he's in the district, he's under the Deputy Commissioner. It is the Deputy Commissioner who has to issue the release order. He has to release the incumbent. Neither the secretary nor the director.
The petition is still pending. So we have to know from the Deputy Commissioner why that person has not been released.
Yeah, that is why lawsuit, contempt has been drawn lawsuit. Sumo motu contempt has been drawn by this Honorable Court.
Against Deputy Commissioner?
Yes, lawsuit.
So what happens to the other two writ petitions?
No, sir, it is still pending in both the writ petition. They have to file their affidavit.
Huh?
The authorities.
So let them file affidavit.
Yes, lawsuit.
Who is appearing in 452 for the government?
For respondent number 3, I'm appearing, my lord.
452.
452 and both the petition, my lord.
For you, ma'am, you are the government advocate?
Yes, my lord. For respondent number 3 only, my lord.
For respondent number 3?
Yes, my lord. For others, my lord, they are standing counsel, my lord. Yes.
For respondent number 3.
Deputy Commissioner, my lord. 3.
Yes. Why Deputy Commissioner is not complying with the order?
For that matter, I have to file affidavit, my lord. I have got instruction.
You have got instructions.
This is complete lawsuit, this subordination of this Honorable Court order. Because lawsuit has seen, the first this modification order was stayed by this Honorable Court in writ petition 452. That was not complied. I was not allowed to join. So I had to move this another writ petition.
Okay, thereafter you had joined.
Yes,
But you are not
I was
to
allowed
discharge
to
any work.
in the piecemeal basis, the Deputy Commissioner is giving me the relief.
No, but
Oh,
so
of
far,
course, I have been
so
allowed
far
to
as
join.
contempt is concerned, I think the matter ends there. Only thing is that now actually you are not allowed to discharge. That is why you have filed the writ petitions. Correct? You are not allowed to discharge your duties.
No, this subsequent writ petition was that lawsuit.
Why have you filed this writ petition? Why have you filed?
I was not allowed to join lawsuit.
You
Now
were not-
I have allowed.
No. You were not allowed to join. That is why you had filed this writ petition.
Second writ petition lawsuit.
So your second writ petition also becomes infractious.
Yes,
Correct?
yes.
What about the third writ petition?
Third writ petition, I have not filed lawsuit. There is only 2 writ petitions.
What about this 526?
526 is for allow me to
Oh,
Join, my lord.
join. So now I have been now allowed.
so everything is finished.
No, this gentleman has to be released from this establishment.
That is for the government.
And
Because your contempt was for you.
lordship, that is for the Deputy Commissioner lordship. he is the releasing authority. It is not the secretary, not the government. It is in the district, DDSC is works under deputy commissioner.
So what you meant to say is that deputy commissioner has not complied with the transfer.
Yes, still he has not complied fully the order passed by this honorable court, because only allowing me to join is not enough, Lordship. I have to be allowed to discharge my duty as DDSC. It can be done only when
Let
this
it also-
gentleman is
See,
released
that's
from.
also- You had filed this contempt petition because you were not allowed to join.
Not contempt, Lordship. Second writ petition, Lordship.
No, this contempt petition.
Contempt, Lordship, it has been drawn this sumoto by this honorable court. I have not filed, Lordship.
Okay. So the first, the writ WPC 452 was filed because you were not allowed to join.
No, Lordship.
You have now joined.
No. 450, Lordship, 452 was filed because after the issuance of the transfer order by which I was transferred to the Pasighat at DDSC, that was subsequently modified. I have filed this first writ petition against that modification order.
Okay.
Then in that writ petition, Lordship, this honorable court has passed the interim order till the disposal of
Not to
this
modify.
writ petition. The modification order will not be given effect.
Okay.
That was the order passed in my first writ
So
petition.
that order was violated or?
Yes, that order was not complied with by the deputy commissioner, so I had to prepare this second writ petition, ventilating my grievances that deputy commissioner is not allowing me to join there at Pasighat at DDSC.
Okay,
So-
so only the.
So
second-
now, in the second writ petition, Lordship, after
Only
filing,
the second writ petition remains. Your contempt as well as the first writ petition goes.
no, Lordship,
Because actually,
to my understanding, Lordship, only allowing me to join as DDSC is not enough. I have to given the charge of DDSC, and I have to be allowed to discharge my duty as DDSC. And it can be done only when.
that is the subject matter in WPC 526. Correct?
Yes,
That
Lordship.
is the subject matter in 526.
Yes.
So far as contempt and 452 are concerned, it no longer survives.
452 is for modification of transfer order, my lord.
Oh, yes.
Huh?
No, that is still here, Lordship, because finality has not been attained, Lordship. It has to be adjudicated, whether the subsequent order by which my transfer order was modified and I was written as a principal, that GECO is correct or not. That aspect has to be.
So we give time. We give time to the deputy commissioner to come up with the instruction as to why this man is not allowed to discharge duties.
Yes, Lordship. Yes, Lordship.
Yes, my lord.
Let's.
Okay. That is in which writ petition should I pass the order?
In 526, my lord.
526.
Yes, my.
Yes.
526.
Yes.
May I please go?
Yes.
Your Lordship, in repetition 526, there is a private respondent.
Okay, you are the private respondent.
Mr. Kemo Lorraine is there.
Okay, you are the obstacle.
Mayor. Lordship, I am appearing on behalf of Mr. Kemo Lorraine. Private respondent.
So have you filed your counter?
We will find it. We need to wait.
Okay, so 452,
Yes.
452, whether you are filing any counter?
Yeah, my lord, in 452, my lord, I think department will be filing.
452, 452.
Lordship, I am appearing on behalf of Mr. Tabat.
Yes, the standing council, my lord.
Standing council, Lordship. Lordship, I did not
Four,
receive a copy of the
452,
petition.
452 is filed against modification.
Yes, my lord.
Yes, Lordship. Yes.
There, my standing council will file, my lord.
Okay. So in 452, WPC 452. You are appearing for?
For the education department, Lordship.
For education, standing council?
Yes, Lordship. On behalf of Mr. Tabat.
Mr. So-and-so? Learned counsel? makes a mention on behalf of Mr.
Dilon.
So and so,
Mention. Tabat.
the Learned Standing Council for Education for school education,
Education Department, Lordship.
for education department. And 6 for 2 weeks' time to file affidavit in opposition. Okay. Prayer is allowed, listed accordingly. Now in 526.
Yes, madam.
Okay,
There, I'm filing my affidavit.
MS Censor. The learned government advocate for the respondent number
3, madam.
3 and Mr. So and so
I on behalf of Mr. Kelo.
on behalf of Mr. So and so, learned counsel for the respondent number 3. Learned counsel for the respondent number
4.
304.
452. 452 deputy commissioner is not a party.
No, he is not party.
No, but sorry, madam. I
In
was-
452, he is not party, Lordship.
I'm not a party man. In 420, 526, I'm a party man.
526.
Yes, my lord.
Have we passed order 526? We passed order, no? No. What order have we passed? 452? 452? WPC 452? What order have we passed? 452. Prayer is allowed, listed accordingly. Okay. Then now 526. MS Senso. The learned counsel for the respondent number 3. And Mr. So-and-so, learned counsel on behalf of Mr. So-and-so. Learned counsel for the respondent number 4. 6 for 2 weeks' time to file affidavit in opposition. Prayer is allowed, listed accordingly. Okay.
Much obliged.
Okay.
May I please, Lord?
Yes.
Yes, my lord, in item number 19, for the petitioner. And item number 20 and 21, my lord, I am responding. My lord, this is regarding, my lord, recommendation petition filed by them, my lord, in election petition, my lord.
What election?
Election, my lord, assembly election.
Assembly.
2019 assembly election. My lord,
Whether a particular judge is designated to take up election cases.
my lord,
Yes, please. That's good. So what is there is a order from the Honorable Chief Justice. Because actually election petitions actually, judges are designated. You just see on 7th. Okay, on 7th. Okay. We'll list it again on 7th.
Your
Okay,
lordship,
on 7th. Because I think there is a specific direction that election petitions. It is only the judge who is designated to take up the case by the Honorable Chief Justice. I think it-
Otherwise, my lord, virtually this petition become infractions, my lord. Because of my lord, the judgment passed by the Honorable Supreme Court, my lord. In my lord, the civil appeal, my lord. My lord, the election petition was allowed by this Honorable Court, my lord. In my favor, my lord. Against that, they have approached to Honorable Supreme Court, my lord. And Supreme Court had dismissed by election petition. By virtue of that, my lord, in terms of that order, my lord, this recommission petition as well as the IA become infractions, my lord. My lord, maybe it can be, my lord, closed, my lord.
yes, your lordship.
And my lord, there was notification, my lord. In event of, my lord, the honorable judges of this one, this designated judges of election petition were transferred to some other, my lord, state or my lord, judges. In
Can you
that case, my
please,
lord,
can you please place that notification on 7th? Please, okay, let me be very clear before I pass any order.
Well,
Okay, listed again on 7/2/2024. Please, okay?
oh,
Thank you.
all right.
Obliged.
Lordship, kindly this matter may be fixed on 5th March.
5th March. You're the counsel for the
Petitioner.
petitioner. On the prayer of,
I took consent from the opposite party.
okay, on the prayer of Mr. So-and-so, learned counsel for the petitioner, listed on 5/3/2024. Stuff, the consent of the other side has also been obtained. Yes, Mr. Tapin.
Lordship, I'm appearing into for the respondents here. I filed my reply also. Lordship.
Opposite, you're for the respondent.
For
State
respondents, yes.
Yes, Lord.
Yes.
I'm for the, my lord, petitioner. My lord, I have filed your affidavit in opposition, my lord. Both the container, my lord.
Just wait, okay, this, Mr. Tapin, you are for 1 and 2.
1 and 2.
Yes,
Yes, my lord, it can be taken up, my lord, for hearing. Whether, my lord, the contempt was made out.
What is actually the which has been contained?
Yes, my lord, this is at page 11, my lord, annex 1, page 11.
Page 11.
Yes, my lord. Operating portion is 8, my lord.
Yes,
Page
yes.
13.
Operative portion is at page
Page 13, my lord. Paragraph from
13.
paragraph
Just
2.
wait, page 30.
Yes, from
Oh,
page 13, my lord. I'll read from paragraph 2, my lord. May I read, my lord?
shit.
Though an affidavit of opposition has been filed by the state respondent contesting the case, Mr. Ratnam, learned additional advocate general ordinance, however, has submitted that since the provisions of General Financial Rules 2017 is applicable in the matter of procurement of goods and services, this writ petition may be disposed of by setting aside the order put to challenge herein by the petitioner and thereafter providing the state respondent to open the financial bid of the petitioner and if upon evaluation of the financial bid submitted by the petitioner, the requirement of rule such and such of the General Finance Rule 2017 is fulfilled, the petitioner financial bid may be considered in accordance with law. My lord, why I am pointing this out, my lord? My lord, this writ petition has been disposed on their proposal, my lord, to set aside the impugned order and give them liberty to see whether the requirement of Rule 173 of General Finance Rule is complied by the petitioner or not. In event that is in consonance with this Rule 173 of GFR, my lord, then, my lord, it will be considered in accordance with law. Accordingly, my lord, in page number 14, my lord, on proposal of the respondent, my lord, the direction was passed. Page 14, my lord. Accordingly, in view of the agreement reached between the parties, this writ petition shall stand disposed of by setting aside the summary of technical bid evaluation made by the board on 6/4/2023, recommending retender of the notice inviting e-tender in question as per Rule 144 and 173/19 of the GFR 2017, and the order dated 26/4/2023, issued by the Secretary, Department of Women and Child Development, Government of Arunachal Pradesh, Itanagar, approving the recommendation of board for retender by the tactical bid evaluation made on 6/4/2023, with a further direction to the respondent authority to open the financial bid of petitioner submitted pursuant to notice inviting tender dated 2/3/2023, issued by the Director, Department of Women and Child Development, Government of Arunachal Pradesh, Itanagar, for procurement of 12,450 medicine kits, and upon evaluation of petitioner financial bid, if it is found that the financial bid submitted by the petitioner fulfills the requirement of Rule 173(20)C of the GFR 2017, the bid submitted by the petitioner may be considered appropriately in accordance with law.
Yes, Mr. Kapil, whether the financial bid submitted by the petitioner fulfills.
Lordship, after receiving this order, Lordship, because the tender was already cancelled after Lordship, the bid of the petitioner has been cancelled, Lordship, because no other bid was there. Once Lordship, technically Lordship, because this online this technical bid Lordship, once the bid has been cancelled Lordship, it goes away from the system Lordship. And to procure it back, to get it back Lordship, we have to write to the NIC Lordship. Who is the Lordship controlling the website Lordship. Accordingly, we have written to the Lordship NIC immediately after receiving the order. And Lordship will find it based in my epidemic Lordship.
or 1 and 2?
Lordship, yes, 1 and 2.
Hmm.
Page 10, Lordship, Annexure 3, Lordship. Just Lordship, page 10.
Hmm.
I'll read from the Lordship, third paragraph, Lordship. Now, the Honorable High Court in so and so have passed directions for opening of financial bid of above refer e-tender. Technically, the department is not in a position for opening of financial bid so and so as it was cancelled in the portal. Therefore, in view of above, I am request you to provide technical assistance for retrieving tender ID number so and so that department could comply the directions of the Honorable. It was written on Lordship 38/2023 Lordship. It was written to the NICA, National Informatics Center Lordship. And then in response to that Lordship, kindly come to next page Lordship. This is a, it's written from their NIC Lordship. This is a gentle reminder to you in continuation.
Just wait, just wait.
Next page Lordship.
Gentle reminder.
General. It is to reiterate that a copy of Honorable Court order is mandatorily required for processing request of your department. So they ask for the copy, Lordship. Then kindly come to the copy of the court order. The NIC asked for the copy of the court order to go with our request, Lordship. Then accordingly on next page, Lordship, this page 12, Lordship. By this Lordship, we have furnished the Lordship copy of the Honorable Court order. Then Lordship, next page. In this way, Lordship, it was ultimately Lordship, it was revoked, Lordship. Kindly come to page 16, Lordship. Page 16, 16, Lordship, Annexure 8. It is to inform you that as per your request, the cancelled tender ID number has been revoked to the previous state, Lordship. Now it has been brought back to the system.
Where are you reading? It is to inform you that as per your request.
Lordship.
This is written by whom to whom?
This is by the Lordship, the NIC to the department, Lordship. Because our tender was cancelled and it was Lordship removed from the portal, Lordship. And portal is being made by the Lordship people of NIC, Lordship, who is the authority. And it was revoked to the previous state. Meaning thereby it was the data was brought back to the system, Lordship, so that we can open it, Lordship. And it was Lordship done on Lordship October. Then accordingly, the tender was fixed on 15th of December for opening of the financial bid of the petitioner, Lordship. Kindly come to next page 17, Lordship. When we Lordship fix for opening of the financial bid, Lordship, then on that day we realized that Lordship, after this tender has been cancelled, EMD of all the bidders they have been returned, Lordship, including the petitioner, Lordship. Then because he has taken the EMD, so without EMD we can't Lordship go with the tender process, Lordship. Then on the same day, Lordship, we have written to the Lordship Geneva. This is the
just wait, just page 17.
Page 7.
This is written to the petitioner.
Petitioner. And requesting him to the Lordship to resubmit the EMD, Lordship. Then the petitioner submitted, Lordship, this his EMD. Then in the meantime, Lordship, what happened? We came to know that Lordship, we received notice from this Honorable Court, Lordship. This order has been challenged before the Honorable Division Bench, Lordship. And
which order?
This same order, Lordship, for non-compliance of which, Lordship, this present contempt petition has been filed, Lordship. The order of this London single bench, Lordship.
This is under challenge before.
It's under challenge before the.
Even presently?
Presently, Lordship. So under this circumstance, the department took advice from the law department. So law department advised that since there is no stay, so you may proceed, but since it's sub judice before the division bench, you may hold the thing till matter is decided by the division bench. So this is the lordship situation under which lordship
Yes, when the matter is pending before division bench, the matter is sub judice.
My lord, that is true, my lord. My lord, but my point, my lord. My lord, kindly come to page 18, my lord. Page 18, my lord. This is dated 15 December 2023, my lord. After 15 December 2023, my lord. They have not, my lord.
Who
taken
has
any
actually?
Yes, my lord.
Who has challenged the single bench order?
My lord, that has been.
one of the bidders.
My lord,
One of the bidders.
One of
yes, my lord. What happened in this case, my lord? My lord, NIT was issued, my lord. 5 firms has participated in the NIT, my lord. Thereafter, my lord, all from 4 firms, they has been, my lord, disqualified in technical bid evaluation, my lord. Only the petitioner was qualified in technical bid evaluation. Thereafter, what the tender recommending committee has done, my lord, they have decided, they have recommended for retender of the NIT and not to, my lord, open my financial bid.
What is the direction of the learned single judge? What was the direction?
to open the financial bid.
The financial
Finals bid.
So that has been challenged before the division bench
Division
by
bench.
one of the tenderers.
One of the.
My lord, my lord kindly appreciated. My lord, this order was not challenged by the respondent, my lord, contender, state
No,
respondent.
that's correct. That's correct.
That has been challenged by one of the bidder, my lord, disqualified bidder, my lord. And my lord, in that appeal, my lord, it is yet to be issued any notice, my lord.
No, but
My lord, that has been, my
that
lord.
disqualified bidder
Yes, my lord.
is challenging the order passed by the learned single judge.
Yes, my
With a-
lord.
for-
He is
for a
not.
direction to open your financial bid.
Yes, my lord. He is not party to writ petition also, my lord. And my lord, somehow, my lord, they have filed the appeal after lapse of 3 months, my lord.
That's all right. The matter is sub judice before a division bench. Will it not be proper? Will it not be proper? Because when the matter is sub judice, although the state is not a party,
Yes.
state has not appealed. But since the matter is sub judice, I think it'll always be good if we can take up the matter after the disposal of the case.
State is a party there, but not as an appellant.
Not as an appeal. Correct.
But my lord, whether my lord, the order of the land Sigar judge, my lord, can be, my lord, kept, my lord, pending at the fate of, my lord, a person who has, my lord, made an appeal.
I am just saying this as a matter of propriety.
Yes, my lord.
As a matter of propriety, since the matter is already pending before the honorable division bench.
My lord,
So,
that is true, my lord. But my lord, only, my lord, there is limitation of 68 days. Only, my lord, notice has been issued in, my lord, say, for condonation of delay, my lord. And that, whether that delay will be condoned or not, that is also a question, my lord. My lord, and there is no any locus to file that appeal by some, my lord, third party, my lord, who has no, my lord, who has no, my lord.
yes, you may be right, but this court is a matter of propriety.
Yes, my lord.
Feels it proper to take up the matter only after the disposal of the.
My lord, kindly come to, my lord, their explanation, my lord. That is very unfortunate.
No, it's all right.
Kindly, my lord, come to page. Dear, my lord, affidavit.
No, when this court
Yes, my lord.
feels that actually the matter should first be disposed by the honorable division bench, let us not go into the matter.
My lord, so I agree, my lord. If there is any impediment, my lord, is not the duty of the respondent to file a, my lord, application before the appropriate bench for extension of time or for modification or alteration, whether it is right to sit over the matter, my lord, because appeal was pending in, my lord, division bench. That's why we are sitting over the matter. Is this, my lord, correct explanation, my lord? In my humble submission, my lord. They have to file one application. If there is any impediment, my lord, they have to file an application, my lord. Way back in, my lord, 2020, means 15 December 2023, my lord, before filing of my contempt petition, my lord, by sitting over the matter since 15 December
Mr. Tompkins,
2023. Yes, my lord.
Are you aware about the appeal number?
Appeal is general. It was filed in year 2023 only.
No. Are you aware about
Exact lawsuit is just lawsuit. I have
Well,
to.
they have mentioned in page 6, my lord. Page 6, my lord.
page 6 of?
Their affidavit, my lord. My lord, this is very unfortunate, my lord. In my humble submission.
Lordship's query is about the status of that appeal. Lord.
No. The appeal number,
Appeal number is there, Lordship. At page 6, Lordship.
page 6.
Meanwhile, department is also in receipt of it, appeal number. Sir.
My lord, in my humble submission, my lord. My lord, what they have done, my lord, they have, my lord, honored the view expressed by the law department, but they have no, my lord, honor of this honorable court. my lord.
No.
Yes, my lord. My lord, they should have filed one application, my lord.
Like this. It's a matter of property as Lordship has already observed. Lordship.
If the appeal is dismissed,
Yes, my lord.
either in the IST or in the on merit,
Yes, my lord.
then I think you may have a very good case.
My lord,
Heard Mr. So-and-so, learned counsel for the petitioner, and Mr. S. Tapin, learned senior. You use the word
Not as a senior government advocate. Yeah. For
because in Nagaland,
yes, Lordship.
there is a notification
Lordship.
asking all the government advocates to appear in contempt matters. So government advocate appears not as the learned counsel, but as a government advocate in contempt.
my lord, before my lord passing any order, my lord, my lord, I like,
Yeah, Lordship.
No,
I would like to
just
place one.
heard Mr. So-and-so, learned counsel for the petitioner, and Mr. S. Tapin. You are designated?
No.
S. Tapin, the learned counsel for the alleged contaminants. From the affidavits filed by the alleged contaminants, it is seen that the writ appeal number 35 within bracket AP 2023 and IA number 189 and 192 within bracket AP 2023 has been filed by one of the tenderer, has been filed against the judgment and order dated
8/8/2023.
8/8
2023.
against the judgment and order dated 8/8/2023 passed by the learned single judge in WPC number 255 within bracket AP/2023 by one of the tenderers. This court accordingly feels that this contempt petition. This court accordingly feels that it will be proper to take up the present contempt petition only after the disposal of the writ appeal which is pending before the Honorable Division Bench. Registry to take steps and list it accordingly. Okay. All right. Okay. Excuse me for 2 minutes. Yes.
My lord, I have only two poll submissions, my lord.
Only 2-point submission. What is the first?
Number one is that, my lord, there is a exceed land occupied by the NSPC.
NSBC means?
National Hydropower Corporation Limited. Second submission is that, my lord, when there is a exit land, my lord, we prayed before your lordship is that we want to deposit some amount for the resurvey or re-verification of the area. This two poll submission, my lord.
Your land in excess has been occupied by the department.
Yes, ma'am.
So you had submitted to the department for survey.
Yes.
What was the outcome of?
As on today, there is no any.
Yes, ma'am. Why don't you survey?
Will bear the cost of the minor survey, my lord.
Huh? Have you filed your affidavit, ma'am?
Yes, Your Lordship. I'm for respondent number 3, Your Lordship.
You are for
Commissioner.
respondent
We have
number
already filed our counter affidavit.
Okay, just where counter affidavit? Where is the affidavit filed by the respondent number 3?
Yes, Your Lordship.
Oh, this is IA.
Oh,
What is your IA?
Yes, my lord. This is I.
In
You have filed your counter in a main writ petition.
Yes, mandatory petition. Your
What
Lordship.
about this IA? Why is this IA filed?
My lord, IA is for my lord, as I have submitted, my lord, the exit area which was not reduced from the measurement earlier done in 2011. So again, thereafter, they have reduced the area and the entire community land is going to be submerged. And my lord, there is also my lord, deputy
Just-
commissioner.
Just wait, just wait. You are the applicants here, nah?
My lord.
And opposite party, madam, you are representing all the opposite
No,
parties?
only Your Lordship, for respondent number 3, Your Lordship.
Oh, deputy commissioner.
Yes, Your Lordship.
What about the others? State, land, Department of Land Management,
On behalf of MCATO, for Union of India.
MCATO. MCATO. So you will be for respondent number 4.
Yes, madam.
What about 5? We will issue notice. We will issue notice. Let us see, because you are praying for resurvey.
Yes, my lord.
Correct.
My lord.
Let us see what they will, what stand they will take.
My lord, I would like to appraise before your lordship, my lord, annexure B of the my lord, page 17, my lord. This is a letter written by the my lord, deputy commissioner himself to the NSPC to resurvey.
Okay, okay. The court will pass orders, but we'll give a notice first. We at least give notice. Okay, at least let us hear the other side. At least let us hear the other side before we issue any notice.
Yes, ma'am.
You are entitled. You are entitled.
My
to resurvey.
humble some prayer before his lordship is that we will bear the cost of this survey.
That's
You
what
need
he
not to
said.
pay anything, my lord. We will.
So you are having a very generous petitioner. He wants to do everything for the respondents. Pay up. Anyhow, we issue notice.
Yes, madam.
Okay.
We need extra.
We issue notice. Let us see. We'll fix the matter after 2 weeks. Let us see what happens. Okay.
No, 1 week.
We issue after 2 weeks.
Because head office is here in state only, Ruing.
This is not the first time. Oh, this is the first time.
First time, man.
So, heard Mr. Your good name?
Tishon.
So and so. Learned counsel for the applicant. This application has been filed. Praying for resurveying / re-verification
Of exit areas, my lord.
the resurveying re-verification of the excess land of New Anaya Village Community, which is under the occupation of MS Dibang Multipurpose Project, within bracket DMP, close bracket, under National Hydro Power Corporation Limited, within bracket NHPC Limited. It is the case of the applicant that MS Dibang Multipurpose Project is occupying the lane. Without paying any lane compensation to the affected landowners. Issue notice to the respondents, returnable within 2 weeks. You are for?
I'm for respondent number.
Respondent number?
4.
4.
On behalf of.
Who is for respondent number 2? MS.
Director Land Management.
Land management, standing
Ah.
council is there.
Who is the standing council?
D Kamdam.
MS, your good name, ma'am?
D Pangu, your lordship.
So and so. Learned counsel, learned government advocate appears for the respondent number 3. And Mr. So and so. Learned counsel appears for the respondent number 4. Stop. The learned counsel for the applicant shall accordingly furnished the requisite copies of the application to the learned counsel for the respondent number 2 and 4 in the course of the day.
Yes, man.
In the course of the day. Insofar as respondent number 1, 2, and 5 are concerned, the learned counsel for the applicant shall take steps for service of notice upon the said respondents by registered post with AD within a period of
3 days.
within a period of 3 days from today. Okay.
My lord, one thing, my lord, we are ready to bear the cost of the.
That is, it's all right. That we will take into
If
consideration.
it is reflected, it will
After
be
2 weeks, we'll take into consideration.
much of it.
This is a very old case. What is the matter about?
This is regarding pensionary benefits, madam. Pensionary benefits, madam.
Your lordship, unfortunately, the counsel for the petitioner couldn't appear today, your lordship. That's why matter may be fixed for day after tomorrow.
You are the counsel for the, you are representing, you are mentioning on behalf of the counsel for the petitioner.
Yes, your lordship.
Okay.
Day after tomorrow, madam.
Day after tomorrow, your lordship.
Mr. So-and-so, learned counsel makes a mention on behalf of Mr. Who?
Miss H. Jaram.
Mr. So-and-so, the learned counsel for the petitioner and seeks adjournment of the case. Prayer is allowed, listed after a week. Okay.
Much obliged.
None appears for the petitioner, listed after 3 weeks. What is the case?
Lord, here, my only son, my lord, die in custody, my lord, judicial custody, my lord. So basically, I am praying 2 things, my lord. One inquiry, my lord, on the inquiry and compensation, my lord. That the 2 prayer I have made in my petition, my lord. This parties are ready, my lord. My lord can hear this, my lord. Right.
You were supposed to file affidavit in reply. The office note 19/4/20 or 19/4/20. Why, madam, you're for the government, no?
Yes, Your Lordship.
Why inquiry should not be constituted?
Firstly, Your Lordship, the inquiry was done under 176, Your Lordship, of CRPC, Your Lordship. In any death in the custody, Your Lordship, the inquiry has to be done by the magistrate. Magistrate inquiry has been done, Your Lordship. They have not challenged it, Your Lordship. We have brought it into the record.
You have not challenged the inquiry?
No.
And you want a second inquiry?
No, my lord. That is not actually inquiry, my lord. That was a judicial action done by the minister and the CRPC, my lord.
Yes.
As a administrative part, my lord.
What-
Here I, my lord, will try to, my lord,
Under what provision now inquiry can be ordered?
My
Under
lord-
what provision? Under which law? Since CRPC, under CRPC inquiry has been constituted and inquiry has submitted the report, you have not challenged that.
No, my lord.
Now under what provision of law inquiry can be constituted?
My lord, my humble submission, my lord, when there is a violation of human right, my lord, by evoking 226, my lord, surely, my lord, inquiry, my lord, when all the thing, my lord, the inquiry, including all the record, my lord, is in cloud, my lord. And if my lord allow, my lord, maybe from the record, my lord, of that respondent, my lord, I will satisfy, my lord, that, my lord, yes, there is something deep inside, my lord, that need to be put in judicial inquiry, my lord.
What is the fact precisely? Let us hear.
Precisely, my lord, may I, my lord.
Just, I may not take up today, but let me.
Precisely, my lord, my son, my only son was, my lord, arrested, my lord, in the allegation of, my lord, theft, my lord. Now, during the according to arrested, my lord. Now, records say, my lord, including the magistrate order, say, my lord, he was produced before the magistrate, my lord, and he died in a judicial custody, my lord. Now, if he go by his sequence, my lord,
He died in judicial custody.
my lord,
Whose report says so? Whose report says?
judicial, all the records, there is a order, my lord, judicial order by the magistrate putting him in judicial custody, my lord. Now, the surprisingly, my lord, in the whole record, my lord, on the record of the respondent, my lord, when I was arrested, my lord, I was produced before for medical test, my lord. There is 2 reports, my lord. Thereafter, my lord, on the basis of that, there is a specific direction, my lord, for better treatment, my lord, in those reports, my lord. Now, on those reports, basis of that was not done, my lord, by the authority, my lord. Now, there is a judicial order say that seen the medical report, my lord. According to put the custody, my lord. Now, from the custody, on the report said, only the record is say, my lord, there he was produced in the other police hospital, my lord. But surprisingly, there is within there, my lord, within the judicial custody, there is a report of the other medical report also, my lord. Now that also, all those say specific on record say that these all documents, my lord, was constructed, my lord. Now constructed, my lord, after date of my son, my lord. On the record, my lord, I may be able to satisfy, my lord, that, my lord, all those record, my lord, medical report. There cannot be, my lord, the person, my lord, who in the judicial custody, my lord, is where in the other medical, my lord, where is their report say, my lord, it should be in the other
what?
medical, my lord, streams, my lord.
Treatment.
Streams, my lord. So there is a normally, my lord, the process here is, my lord, person in judicial custody normally goes to the RK mission, my lord. Now they are their records say, my lord, from the judicial custody he has brought to RK mission, my lord. But
He has been brought to?
RK mission hospital, my lord. But there is their own documents say, my lord, within those periods, my lord, there is a report of the streams also, my lord. Tomboriba hospital and Nahalgaon, my lord. Now, I would say, my lord, hold this, my lord, from the record of their, my lord, that documents, my lord, was constructed, my lord. As, my lord, when I was produced before the past medical officer, my lord, there was a specific, my lord, advice, my lord, I need a better treatment, my lord, CTC need to be done, X-ray be done. That was not done, my lord. I was brought with the magistrate where that was produced, by record say which was produced, my lord. I was remanded to judicial custody, my lord. Yes, I was not given treatment, my lord. They performed to do their solemn duty, my lord, to protect my life under Article 20, my lord. That's why, my lord, I died, my son died in custody, my lord. That is my allegation, my lord. Now, my lord, they said, my lord, they say, my lord, I was not, my son was not beaten up in a custody, my lord. They say my son was beaten up by the public, my lord. Now, what they had done, my lord, to brought injustice those culprits, my lord, nothing, my lord.
Now, my humble submission, my lord, they have miserably failed to perform their solemn duty under Article to protect the right under Article 20 under Constitution, my lord. Therefore, my lord, I am entitled to compensation, my lord, and inquiry, my lord, to who were involved, my lord, to do the solemn duty under Article 21, my lord. That is my humble submission, my lord. On the record, if my lord allow, my lord, I'll satisfy my lord.
Yes, madam, let me.
Yes,
also-
Your Lordship, if I may in brief make gist.
Just give me the.
Yes, gist of the case, Your Lordship. What has happened was an FIR was filed that he has stolen the scooty of some person, Your Lordship, the complainant. Thereafter, when he was caught by the mob, Your Lordship, they have beaten him on the spot. Subsequently, an arrest was made. Arrest was made on 22, Your Lordship. On 23, as per the procedure, he was sent for the medical checkup, Your Lordship. Your Lordship will see, he was firstly to the nearest CHC, which is at Karsingsa. He was taken there. There he was referred to for further treatment to TRIMS. And he was taken to TRIMS on the same day, Your Lordship. Subsequently, he was arrested on 22. He was taken for medical on 23. On 24, he was forwarded to, since he had a chest pain, Your Lordship, he was forwarded to MO to RK Mission Hospital. On examining the accused, Your Lordship, he was referred for X-ray on 20. He was referred for X-ray or also of the other examination, Your Lordship. His X-ray report came on 25th and his other report came on 26th. Now, during this his medical examination, there was a conclusion that he has a pulmonary TB, Your Lordship. On 27, he was to be referred and transferred to other hospital, Your Lordship, when he unfortunately, because of his illness, had succumbed to his illness.
What is the cause of his death?
Yes, Lordship.
What is the medical report which shows the cause of his death?
TB, Your Lordship. TB. Now, yeah, expectation due to TB, Your Lordship. He has a breathing problem, Your Lordship. From the first day when the medical checkup was done, Your Lordship, all the X-rays and his injuries were all reported in the entire medical report, Your Lordship.
Hey, ma'am, I think it will be next to impossible for this court to dig out all these things.
Yes.
Will it not be proper to set up?
No, Your Lordship, I'm suggesting what subsequently did after he was declared dead and his inquest and his inquiry will be done. If Your Lordship will come, so kindly come to CRPC, Your Lordship. 176, what does it say is inquiry by magistrate into cause of death. The case is of natural nature referred to in clause 1 or clause 3, 2 of subsection 3 of section 174. The nearest magistrate empowered to hold inquest shall and in other case mentioned. So any magistrate may hold into cause of death either instead of or in addition to the investigation held by the police officer, and if he does, he shall have all the power in conducting it which he would have hold an inquiry into an offense. A1 says any person dies or disappears or rape is alleged to have been committed on any. Now, as per this, Your Lordship, 176, Your Lordship, after his death, Your Lordship, which is in our affidavit, Your Lordship. That inquiry is conducted by the magistrate when even the statement of his wife later on denied that wife, Lordship. Statement was also all the medical reports were taken into consideration. Also, the other inmates with whom this person was, and a conclusion was made that he had died of there was no torture or immediate cause on the death of so and so and natural death, Your Lord. That inquiry, that was the final inquiry, Your Lord.
I try to obtain my those all medical report inquest extra report Mr. Try to CTC my that was not given to me, my lord. Now my humble submission, my lord. Who conduct
Visit order, my lord. That also is under that, my lord. And
That is also what?
under the cloud, my lord.
Under?
The cloud, my lord. It is under
Oh, you
doubtful.
changed
They,
that?
they have challenge in that case.
My humble submission, I'm no need telling all those things, even all those things accepted, my lord.
Okay.
On the record, my lord
At
will
least,
see.
at least you bring that on record. At least let the court examine.
But that is on the record, my lord, by the they have filed affidavit opposition, my lord. I'm not, my lord, even
Why? What is the reason why you have not brought that on record?
my lord, that I made a categorical statement, my lord. The petitioner begged to submit the petition to know the exact reason of death of the accused. Submit the application dated 2010-2017 to her council, Chief Judicial Magistrate UPR, polling certificate, copy of the post-mortem inquest report, etc. of the deceased, but same will not provide to the petitioner council, my lord. That is the reason, my lord, I could not brought in my record, my lord. However, my lord, humble submission, even my lord, from the record, my lord, it is not, even if their record is accepted as a truth, my lord, then also, my lord, from the record, I will satisfy, my lord, that the respondent, my lord, miserably to pay to their solemn duty under to protect the life of a person under Article 21, my lord. That right to life, my lord, under protected under Article 21 is also entitled to the prisoner also, my lord.
That is okay. That is okay. But suppose if somebody dies,
My lord.
out of some disease or all this, then
also, my lord,
in that case, I think maybe he was destined to
even, my lord, my lord, I accept, even we accept that, my lord, he ultimately he died of the tuberculosis, my lord. Then the process, my lord, I may be able to satisfy, my lord, that my lord, the pay to their solemnity, my lord. When they pay their solemnity under duty under Article to protect Article 21, my lord, my humble submission, my lord, there is a necessity of inquiry and to necessity of compensation to the petitioner, my lord. I'm not disputing whole the allegation. From their record only, my lord, I will make a submission, my lord. Whether in this case, my lord, some inquiry is necessary, my lord. Particularly, my lord, to my lord, when some action, my lord, on the judicial is necessary, my lord.
Who will be the right authority, the appropriate authority in inquiry?
My lord, my humble submission.
Who will be the appropriate authority? You kindly enlighten this court.
My humble submission by the some retired judge or by the sitting session judge who were not there in this division, my lord, outside this division, my lord. From UPR division, my lord, outside.
If I may
outside,
give a small suggestion, Your Lordship. If their only prayer is for inquiry, Your Lordship, my mission here is that an inquiry has already been made, Your Lordship. Now, if that inquiry is to be Lordship, the challenge of the inquiry will take into consideration that magistrate, while inquiring, has made any lapses on his part while not considering the evidences, Your Lordship. Because if his only prayer is for inquiry, the inquiry has already been done. There has to be a challenge to the inquiry where this court.
My lord, other side, misunderstand me. I'm not saying I'm not saying that I am saying, my lord.
Because if
I'm
he
not
is suggesting it has to.
I am saying the whole process, how they pay to do the perform their duty. I'm seeking inquiry on date, my lord, not the cause of my death, my lord. Whole process, how they pay to whole this need to be inquiry, my lord. It's not only the cause of death, my lord.
Yes, for that the inquiry itself has to be challenged.
Ultimately, the magistrate who passed the judicial order, it is the inquiry report is by himself, my lord. So I'm not that making argument and all those things, my lord. Let it, my lord. My lord will allow me to make submission, my lord. And
have you formulated the questions for which inquiry should be made?
No.
Have you formulated?
My lord.
Have you formulated?
My lord. First, my lord.
Please answer me.
Yes,
have
my
you
lord.
formulated?
Not in petition, my lord.
Formulate and come. Let us on the next date. Formulate the issues for which inquiry has to be conducted. Then let us see whether actually you have a case.
My lord.
You formulate the issues.
My lord, my lord.
We are giving you that liberty at least. If not, you have not challenged the obstacle is that you have not challenged the judicial magistrate's inquiry report.
My lord.
So let us see.
Yeah,
You
my lord.
formulate the issues and come. I'll give you 10 days time. You formulate the issues. Suppose if an inquiry is to be set up,
My lord.
what are the issues to be inquired into?
My lord.
Issues that you have to formulate. Let us see. But don't try to be very slippery, because actually like the magistrate report is already there.
My lord, my humble understanding, my lord, those report, my lord, was that was his duty as an administrative, my lord.
No, sir,
Here I am seeking for judicial inquiry, my lord.
He has actually like conducted a judicial inquiry. Judicial inquiry has been conducted. You are not satisfied. And you have not challenged. So this court wants you to actually frame the issues for which inquiry is to be conducted. You frame that issues and come. Then we'll discuss. Okay, Madam Jenny?
Yes, Your Lordship.
Yes. Mr. Your good name?
El Parmi, my lord.
So and so, learned counsel for the petitioner. Miss Jenny, learned government advocate, correct?
Yeah, APP, Your Lordship.
You are appearing as a additional
APP,
PP?
yes, Your Lordship. He'll be for the government.
I am for the government.
Learned additional public prosecutor and Mr. So and so, the learned government advocate. Listed after 10 days. On which stop, listed after 10 days, stop, on which date? The petitioner shall frame the necessary issues for which inquiry is prayed for is to be conducted. The proposed issues, which is framed by the petitioner for inquiry, shall also be furnished to the learned additional public prosecutor as well as the learned government advocate. Okay.
Obvious, my lord.
Deeply.
The matter is over. Okay.